In this series of videos, we will start with very discussion regarding High Court's writ jurisdiction as provided under Article 226 of the Constitution. So we found a basic difference between Article 32 and Article 226 of the Constitution regarding writ jurisdiction. While in case of Article 32, the Supreme Court had exclusive jurisdiction only relating to violation or infringement of fundamental rights, but in case of Article 226, the High Courts have the power of judicial review of infringement or violation of fundamental rights. Besides that, some other legal rights comes under the jurisdiction of the High Courts under Article 226. And as regarding the very writ jurisdiction that already we have elaborately discussed under the administrative law, also under the constitutional remedies, and also in relating to certain fundamental rights as such. Article 21, which completely relates to life, right to life and personal liberty. So in those previous videos that we have uploaded, we have completely and in detail touched all the aspects relating to fundamental rights and the very writ jurisdictions also. We have already discussed briefly about the writs such as habeas corpus, mandamus, certiorari, prohibition, and quo warranto. And in this particular video, we would like to discuss the very scope that we found of the writ jurisdiction of the High Courts, and in that context, we will discuss the very rulings of some important leading cases regarding the very scope of Article 226, and in that connection, we would like to discuss the very ruling of the Supreme Court in the first important leading case, that is SMD Kiran Pasa versus Government of Andhra Pradesh in 1990. Supreme Court expressed that the power of the High Court to issue writs under Article 226 is wider than that of the Supreme Court. It is not confined to fundamental rights but extend to all cases where the breach of a right is alleged. And also in that important leading case, we found another pronouncement. The scope of the power to enforce fundamental right under Article 32 or 226 is both protective and remedial. Hence, to reject such petition on the simple ground that it cannot be entertained because of a rule of practice of the court cannot be justified, as it was pronounced by the apex court in this important leading case. And now we'll go to another important ruling of the Supreme Court, and that is Amit Vahai Anil Chandra Saha versus CBI. In 2013, Supreme Court expressed that a case of fresh investigation based on the second successive FIR not being a counter case filed in connection with the same or connected cognizable offense alleged to be committed in the course of same transaction and in respect of which, pursuant to the first FIR, either investigation was underway or final report under section 173 subsection 2 of the Criminal Procedure Code was forwarded to the magistrate would be liable to be interfered with by the High Court under Articles 226 to 27 of the Constitution, as it was pronounced by the apex court in this important leading case, Amit Y. Anil Chandra Saha versus Central Bureau of Investigation in 2013. And now we'll go to another important ruling that is relating to the leading case, Kavi Raj versus State of Jammu Kashmir in 2013. Supreme Court expressed that it would be proper for a writ court to refuse to interfere where reasons were given in labor court findings of fact that respondent were employees of appellant and not of constructor, as it was pronounced in this important leading case, that is Kaviraj versus State of Jammu and Kashmir in 2013. So also we would like to discuss another important leading case, and that is Prativa Cooperative Housing Society Limited, State of Maharashtra. In 1991, it was pronounced that the High Court under Article 226 cannot sit as an appellate court on administrative decisions. It cannot interfere in the absence of illegality, unconstitutionality, want of jurisdiction, or malafide. So now we'll discuss another important ruling, and that is relating to Rajasthan State Road Transport Corporation versus Santosh in 2013. It was pronounced that it is permissible to courts to issue direction if the law does not provide a solution of a problem as an interim measure till the proper law is enacted by the legislature. And now we'll go to the ruling of another important leading case, that is Ali Jihad Naqvi versus Allahabad Development Authority in 2001, and it was decided by the Allahabad High Court, where it was pronounced that the writ jurisdiction under Article 226 cannot be invoked for enforcing the contract between the petitioner and the respondent, that is the Allahabad Development Authority. And now we'll go to another important ruling of the court, and that is Indian Soaps and Toiletries Maker Association versus O.J. Roshan in 2013, Supreme Court expressed that the executive cannot be directed by the High Court under Article 226 of the Constitution to exercise power by way of subordinate legislation pursuant to power delegated by the legislature to enact a law in particular manner as it was pronounced by the apex court in this important leading case, Indian Soaps and Toiletries Maker Association versus Ojirushan. And now we'll go to another important ruling of Supreme Court in 2017, and that is Girish Kumar versus CBI. The very ruling was in 2017, where it was pronounced that the jurisdiction of the High Court under Article 226 and 227 cannot be curtailed, yet extraordinary situations could arise where it would be advisable for a High Court to decline to interfere with the interlocutory order as it was pronounced by the apex court in relation to this particular leading case, and as it is relating to the very scope of the High Court, and in relation to that also we would like to discuss some other important rulings regarding the very scope of the High Court on writ jurisdiction. And in that case, this scope of judicial review is very limited, where the courts are not at all equipped to decide upon the viability and feasibility of the particular project as it was expressed by their apex court in the very leading case, and that is K. Vijayalakshmi versus Government of Andhra Pradesh in 2013. Also, it was pronounced that judicial review would lie if appointment of civil judge is not in accordance with Article 234 of the Constitution, and there is any breach or departure from the provisions of this article or state judicial service rules. And now we'll go to another important ruling by the Supreme Court in 2014, and that is Kulja Industries Limited versus Chief General Manager of BSNL. And in that particular leading case, it was pronounced that the freedom of contract or not to contract is unqualified in the case of private parties, but any such decision is subject to judicial review when the same is taken by the state or any of its instrumentalities, as it was pronounced by the Supreme Court in this important leading case, Kulja Industries Limited versus Chief General Manager BSNL. And now we'll discuss another important ruling of this apex court in regarding the very scope of judicial review that the writ jurisdiction of high courts and the very leading cases M. Manohar Reddy versus Union of India in 2013, the Supreme Court pronounced that in matters relating to appointment of High Court judges, judicial review may be called for on two grounds. One is lack of eligibility, and the second ground, lack of effective consultation, as it was decided by the apex court in this important leading case, M. Manohar Reddy versus Union of India in 2013. And now we'll go to another important ruling, that is in the leading case, Binod Kumar versus State of Haryana in 2014. The Supreme Court expressed that if the administrative orders are manifestly unjust or outrageous or directed to an unauthorized end, they can be set aside as arbitrary and unreasonable by the court in exercise of power of judicial review. And now we'll go to another important leading case, and that is Arun Kumar Agarwal versus Union of India in 2013, decided by the apex court, where Supreme Court pronounced that the matters relating to economic issues have always an element of trial and error, and so long as the trial and error is bona fide and with best intentions, such decision cannot be questioned as arbitrary, capricious, or illegal. So now we'll go to another important ruling of Supreme Court in the same year 2013 in the leading case, R. Mohalingam versus Chairman TNPSC, and in that particular leading case, the apex court pronounced that if the court comes to the conclusion that the inquiry was held in consonance with the prescribed procedure and the rules of natural justice, and the conclusion recorded by the disciplinary authority is supported by some tangible evidence, then there is no scope for interference with the discretion exercised by the disciplinary authority, as it was pronounced by their lordship of the Supreme Court in 2013 in this important leading case, R. Mahalingam versus Chairman TNPSC. So now we'll go to discuss another important ruling of Supreme Court in the same year in 2013, and that would be the last important leading case relating to the very scope of writ jurisdiction as found under Article 226 of the Constitution, and the very leading case is Devendra Pal Singh Bhular versus State of National Capital Territory of Delhi, and in 2013 it was pronounced by the Supreme Court that the decision taken by the President under Article 72 or the Governor under Article 161 of the Constitution on mercy petition can be interfered with by the court if it is found that the decision has been taken without application of mind to the relevant factors, or the same is founded on the irrelevant consideration, or is vitiated due to malafide or patent arbitrariness, as it was pronounced by the apex court in this important leading case while making the very pronouncement regarding the scope of Article 226 and High Court's jurisdiction in this important leading case. Devendra Pal Singh Bhular versus State of National Capital Territory of Delhi 2013, and in our next upcoming video we'll discuss the jurisdictions of the high courts as enunciated and pronounced by the Supreme Court, and so also by all other different high courts of in different states, and that we'll discuss in our upcoming video.